Beauty lies in the eyes of the beholder. This statement implies that the definition of the word beauty is subjective. What does the word subjective mean? One dictionary definition is that it belongs to the subject. Beauty is what the subject thinks it is. Objective, on the other hand, means a judgment that is not influenced by personal feelings or opinions in considering and representing facts. For example, if you are a historian, you would write the history objectively, which means you will not let your personal feelings or opinions come to play when you state historical events. What approach, subjective or objective, do the English courts prefer to use to find the intentions of the contracting parties? In most circumstances, the courts, through the use of reasonable person test, would decide what would have been reasonable for the parties to have thought when consenting to a contract. In simpler words, they are thinking about the mindset of a reasonable person and not the mindset of the actual subjects or the contracting parties. This means that they use objective approach to find the intentions. The idea of agreement was the vehicle which the courts used to invoke the idea of individualistic consenting. It was said that there should be a meeting of minds in order to establish a contract. However, we should not imagine that the courts would concern themselves with what the parties were actually thinking at the time they entered into an agreement. It is important to keep in mind that not all agreements are contracts. Although courts are concerned with the enforcement of promises voluntarily entered into, the courts will look for certain elements in an agreement to pronounce it a contract. And that agreement is only enforceable by the courts if all the elements of a contract are found. If all the elements of a contract are not found in an agreement, it is not really a contract and therefore not enforceable. Typically, a contract is taken to the court of law when there is a dispute about one or more of these elements that I just mentioned. The first element is a valid offer. As law students, you must be able to take a scenario, analyze it, and should be able to argue whether the purported offer was indeed an offer. Therefore, in this lecture, you will learn how to identify an offer. In order to understand the case law presented in this section, you should also be aware that the second element of a contract is the unconditional acceptance of that valid offer. An online subscription can be a good example to consider. Are you offered a product or a service? Is there acceptance required on your part?